Mr. Rehnquist.
Good morning. May it please the Court, Jim Rehnquist for Benjamin Laguer. Mr. Laguer has been in prison for the last 23 years, and this case is about suppressed, partially lost evidence that might have affected that result.
Mr. Rehnquist, let me ask you, isn't the key to this case in the fact that Mr. Ettenberg, the trial attorney, in his affidavit says that I understood at the time of trial that the partial print, and I'm quoting, could not be matched to Benjamin Laguer. So the trial attorney, who was an experienced trial attorney, knew at the time that the print, the only print that was found, supposedly, couldn't be matched to his client. So that even if, so he knew there was no physical evidence that matched the defendant to the apartment, and he argued that at trial. The additional print evidence, which was, let's assume, withheld, just is cumulative of that fact. Doesn't change it. It's just more of the same evidence.
I disagree with that, Your Honor, for the following reason. What Mr. Ettenberg understood the state of play on the fingerprint evidence to be as he went into trial was that the small partial fingerprint that existed could not be matched to Mr. Laguer. He did not know that there were, in fact, 4 fingerprints that had been compared to Mr. Laguer's and determined that they were not Mr. Laguer's fingerprints. In other words, it is a subtle, but I think it is a critical difference. And obviously,
isn't it a cumulative difference?
I don't think it is cumulative, Your Honor.
The words that were used when this was reported back, negative, not inconclusive, not we can't do anything with it, the ostensibly one partial print, but negative. And that word was communicated to Mr. Ettenberg.
You keep arguing in your brief that it was inconclusive, but the words that were used by Mr. Ettenberg, which we have to assume is most favorable to your client, twice he says, I was advised the test for the fingerprint came back negative, and I understood at the time of trial that the partial print could not be matched. So there's no inconclusiveness, although you keep talking in your brief about inconclusive fingerprint evidence.
Well, I think the key is Mr. Ettenberg says in his affidavit that he understood that the small partial fingerprint that was found could not be matched. Not that it and
well, there's nothing inconclusive about that. You'll agree.
Well, it is inconclusive in the sense that I think as his affidavit can be interpreted, he understood that for whatever reason this could not be matched.
I take it, Mr. Rehnquist, the point that you are trying to make is there were 4 fingerprints that were sufficiently clear that the expert said these are not the fingerprints of Laguer. Those Mr. Ettenberg did not have. What he had was a fingerprint where the expert said, I can't match, but I can't not match either.
That's not what the evidence was. The evidence was that, according to Mr. Ettenberg, that the partial print could not be matched. That's a negative match. That's, as anybody who's tried criminal cases knows, a not match means it doesn't match the defendant. That's all anyone's interested in when you're making a fingerprint match.
Well, yes, but why could it not match the defendant? Could it not match the defendant because there was insufficient fingerprint material?
He could have asked. Mr. Ettenberg was the one at trial, according to the. I haven't read all of the transcript, but according to the parts that were quoted in the Commonwealth's brief, Mr. Ettenberg was the one who limited the cross-examination of Detective Carrigan to only what he knew. If he wanted to ask more questions, he didn't. Your client's attorney was the one who limited the questioning as to why it wasn't a match.
Well, he limited the questioning as to why it wasn't a match because he didn't know what the answer to the question was. If he had been given, as the government had an obligation to do, the entire fingerprint report, 4 prints that were concluded not to be Benjamin Laguer's, in other words, they were someone else, then he would have made different tactical decisions about how to cross-examine the detective. I mean, I think it's somewhat unfair for the government to benefit from the fact that it wasn't disclosed and to say that Mr. Ettenberg should have done something different.
I'm curious. Now, were requests made by defense for fingerprint evidence? Specific,
yes. Multiple.
Once, twice?
Three times, Your Honor. There was the standard pretrial report that became entered as an order of the court requesting the results of all scientific tests. and after that there were two specific written follow-up requests for fingerprint reports or fingerprint analyses by Mr.
And
Ettenberg.
the response to the request was there's one partial print that is inconclusive.
No, negative.
No,
Negative. That
negative.
is-
Well, I think, and we're disagreeing about how that response should be interpreted. But
I'm
what Ms.
taking the words from you, from the affidavit that you submitted, and the affidavit isn't inconclusive. Mr. Ettenberg says twice, could not be matched, doesn't say anything about inconclusive.
Well, I think that you're correct. He does not use the term inconclusive, but what he also says in the affidavit is what he understood that to mean was that it could not be matched.
Well, could not be matched to the defendant. That's what it means.
Right, and there are multiple reasons why a fingerprint could not be matched. And again, we have to understand the context. What he understood was that there was a single partial fingerprint, and what his understanding was that that could not be matched to the defendant. And he did not know. What he did not know was that the defendant had been definitively eliminated as the source of those fingerprints, which I think it is. It's a subtle difference, but I think it is a critical difference. I mean, it's the difference between having...
Well, what does a negative match mean to you? I mean, a negative match means that the defendant could not be matched to this print. Admittedly, he didn't know about the four others. Or, well, we never know whether this one is one of the four or whether there are five in total. I don't think
That's correct. We don't know that, Your
We'll
Honor.
never know that. But a negative match means that as to one print anyway, your client was not matched to that print.
That's correct. In other words...
Did he know it was partial?
Pardon me?
Did the trial defense counsel know it was a
Yes, it
partial
says right
print?
in the affidavit
Yes,
that the partial print could
So
not be
if
matched.
he is concerned, I take it, that if he inquires further, is the reason why you cannot match because it's a partial print, and the expert says yes, then he's laid open the possibility that the prosecutor could argue that, well, it could be Mr. Laguerre's, members of the jury, or it might not be.
Right. One way or
Right?
the other. We just
One
don't
way or
know.
the
And
other.
that's a door that he
If
was...
you've got four that say this absolutely isn't Laguerre, and then you've also got this partial print, you are in quite a different position.
I agree, and I think it is a subtle, but it is a critical difference, I think, and that's why I would submit this evidence is not merely cumulative of what Mr. Ettenberg understood.
What is the status of the DNA evidence in this case? Is there DNA evidence linking him to this crime?
Your Honor, there were DNA reports that were prepared
At his
within the last
request.
6 or 7 years.
At his request.
At his request. They were not part of the trial in 1984.
And what do they show as a result?
What they show as a result is there is some consistency between the DNA and Mr. Laguerre's blood type. You know, I was not the
Are we having,
attorney.
therefore, a big academic discussion today? Because if this man is retried, that DNA evidence will sink him.
Well, that evidence has never been subjected to the admissibility, whether or not that DNA is admissible, and what a jury will make of that DNA is something that will come up in any retrial that this court orders.
A similar question along the lines of Justice Craney's is I'm wondering, and I know that this would not affect the decision on a motion for new trial, but it would affect a retrial. When did your client mix his saliva with another inmate's saliva in order to obstruct the Commonwealth's attempt through blood typing tests to connect him to the crime? When did he do that?
I think
when did he
that-
make the admission?
I think that this is based on a statement that he made in a parole hearing.
And what was the question that provoked that answer?
I'm not sure exactly, Your Honor. The Commonwealth alleges that this was something that he did when he was in custody awaiting trial. But I
But he
think
admitted it under oath in a parole board hearing, is that correct?
that's the Commonwealth's allegation, Your Honor. I'm not sure the context is entirely clear as to when this may have happened or not. But
I'm sorry, go ahead.
But again, I think that is evidence that will be vetted and attempted to be introduced by the Commonwealth in any retrial that's ordered. It's not. I would submit, Your Honor, that it's not properly part of the analysis as to whether he got a fair trial.
That's correct,
in
and I
1984.
assumed that in my question.
Could I
Mr. Sussman?
change it? Your brief suggests at various points that had this fingerprint evidence been properly disclosed, that there would have been some attempt made to match it to the other third-party culprit, Mr. Gomes or Gomez.
Gomez.
And I'm a little bit troubled by that for two reasons. One is, I take it there was no attempt to check the known partial print against Mr. Gomez. This is something that defense counsel declined to do for, I think, rather apparent and sound strategic reasons. If he didn't do it then, well, I mean, he could have. He knew there was a partial print. He knew that it was negative as to Laguer. If he wanted to try to say it's negative as to Laguer and it's positive as to Gomes, he could have requested access to that partial print to test.
He did, Your Honor, 3 times, and he never received the fingerprint
No,
report.
he never asked, I want my expert to have access to this partial print, which he was informed about, to try and link it to Mr. Gomes. And it seems to me, if he didn't do it with the evidence that he had, why should we assume that he would have done it with the 4 prints? It's a bit dicey, quite frankly, to go out and try and match it to your third-party culprit, because if it matches, that's great, and if it doesn't, it takes away from your defense. It's almost better to have it be shrouded in sort of mystery and doubt.
But, Your Honor, Mr. Edinburgh, the trial counsel, was never given the opportunity to make a fully informed tactical decision along those lines.
But he admitted he
match
had
the
the
one print he
partial
knew about.
print.
He requested the fingerprint analysis and the fingerprint report multiple times. He never got it.
He could have, if he knew about the partial print in sufficient time before the trial, if he wasn't getting something that he wanted, he could have filed a motion before the judge and said, I know there's a partial fingerprint. I want the basis for this analysis, and I want to present it to my expert. It's done every day.
But I think that unfairly puts the burden on the defense instead of the government to turn it over under Healy.
But you're asking us to hypothesize what he would have done had he had the other prints, and there's no reason to assume that when he didn't do that with the one print for exactly the reason that Justice Saussman states, and for the exact reason that it's never done, because that's the last thing the defendant wants, is to find out that this print doesn't match Gomes or it doesn't match whoever he's suggesting is the third-party suspect. He wants to leave it unknown.
Well, he made multiple requests. He never got the report. He may well have assumed that there wasn't a report. I mean, he may have assumed.
But he knew that. He said that he was told that the test for the fingerprint came back negative. So he knew there was a test, and the only way of testing is by making an analysis. He could easily have gotten that if he wanted to.
Well, I mean, he did make multiple requests for it. And under Healy, this Court's decision in Healy, when an order is entered by the court, the defense counsel, that ordering material to be turned over, defense counsel can reasonably rely on the fact that the law creates a presumption.
There's no claim in any of your materials that the defense made a request for the partial fingerprint test and did not receive it. The claim is that they didn't receive the one page of the allegedly two pages.
He asked for all finger. I'm sorry.
He didn't request the physical print itself to have his own expert try to match it to Gomes, correct?
He requested the.
He requested reports, but your expert can't go from reports. Your expert needs the actual print to see if it matches yet somebody else.
I mean, my understanding is that typically the prints themselves are part of the report and are memorialized in the report. I'm not sure that.
That's not right. The report is, as you've got the report. You've got that one page of a two-page report. The fingerprint analysis is totally separate. It's all sort of inked things that are all very messy. And
but it's unclear what else was part of that report. I mean, the report is one page. It appears to have had a second page that was lost or destroyed. It may be the case that the actual fingerprints themselves were incorporated into the report as an addendum.
Could I ask also in the same vein? I've been wondering whether, for this limited purpose, the DNA evidence is perhaps properly considered on this motion, because we're now looking at what's the likelihood that these prints could have been matched to Gomes, which is, again, one of the theories that you're postulating in your brief. In light of the DNA evidence, albeit it hasn't yet been thoroughly vetted and cross-examined and all of that, the likelihood that those prints belong to Mr. Gomes looks exceedingly, exceedingly slim. Why isn't it proper for us to take the DNA evidence into account on that limited portion of your argument?
Because that evidence is not part of this record. That evidence has not been, no judge anywhere has ever considered any objections to that evidence and judged it to be credible and properly admissible in a court and considered by a jury. And I don't think that this court should do that for purposes of this appeal. If there is a retrial, that evidence will be subject to the tests of Lanigan and
Weren't these tests performed by the defense expert?
They were, Your Honor. They were done by the defense expert as monitored by an expert from the Commonwealth.
And weren't they done after several days of hearings by Judge Hillman to try to establish the fairest type of protocol to make certain that there wouldn't be questions afterwards?
Judge Hillman did consider the matter and did adopt procedures and so forth. Yes, he did.
Mr. Rehnquist, what do we know about these 4 fingerprints? Were they 4 prints from the same person, 4 different people? Do we know anything about that?
I don't think the report is crystal clear on that, Your Honor. We do know the fingerprints were taken from an instrumentality that was almost surely handled by the perpetrator of the crime. But I don't think the report on its face, and that's sort of all we have is the report on its face, indicates definitively that they were taken from a single person.
But that more than likely would have been an argument that defense would have made if they'd been aware of the existence of the prints, that it was an instrumentality that was probably used.
Well, that's indisputable that it was. The victim's hands were tied with the phone cord, and almost surely, this was one of those old trimline phones, almost surely the assailant had to remove the cord from the base of the trimline phone, had to grasp the base of the phone in order to pull the plug out.
But isn't it true as well that there were numerous police in the apartment all during the day who most likely, this was in the days before cell phones, back in the 80s, were using that phone all day long to make calls back and forth, and so the fact of prints on the phone, plus of course the victim's prints. But
I think that's not an inference that can be justified, Your Honor. I mean, the area was secured by the lead detective, and the actual phone was judged to be such a significant piece of evidence by the lead detective that he immediately, before doing anything with any other physical evidence, sent the phone itself to the state police lab.
But that was before he had encountered the defendant, who was wearing the same clothes as the victim said and who had scratches on his back, fresh scratches that he lied about, and it was before all sorts of other evidence. So at the time, it loomed as more important than it turned out to be later in the investigation.
It certainly may have been more important at the time, but and certainly it was important that the defendant character had no problem lying about it at the trial.
I have one important question that I didn't get from reading the briefs, and I don't know if I'll get it from reading the transcripts. Was the assailant described as wearing any type of footwear other than socks? Was he described as wearing sneakers or shoes or anything?
I believe the victim's description was that he was wearing socks.
And socks and jogging shorts and nothing else?
I believe that's correct, Your Honor.
Doesn't that alone mean that it was somebody from within the complex? Because people who are going out to commit a rape or something, it's unlikely they would go out without at least sneakers if they were outside, no matter what time of year.
You know, that certainly is something that may have been suggested to the jury as a factor. I think the evidence was that Jose Gomez also spent time. The defense theory was that someone else had done it. I think that Jose Gomez was also someone who frequented the same apartment complex.
But did he reside within this building, not complex, building?
I'm not sure if he resided in that building, Your Honor.
Seems to me that's a key piece of evidence, that somebody is walking around about to commit a very serious crime without anything on his feet other than socks, and it limits it to the people within the building.
Your Honor, whoever committed this crime was obviously a depraved maniac, and to posit that kind of rationality to the behavior of whoever would commit this crime, I'm not sure is correct. I mean, I do understand Your Honor's point.
So, Mr. Rehnquist, how many years after the defendant made the several requests for the fingerprints did you find out about the existence of these fingerprints?
2001, Your Honor. So in other words, that the trial, the requests were made as part of pretrial discovery in the second half of 1983, and the fingerprint report was turned over in 2001. Mr. Laguer himself made a FOIA request in 1995, and that request was ultimately sharpened by counsel he hired in, I think, 2001, and the reports were turned over then, essentially 18 years after the request made as part of discovery.
Thank you, Mr. Lindquist.
Thank you, Your Honor.
Ms. Hartnett?
Good morning, Justice Marshall. I have a couple follow-up answers to questions posed by the court. First of all, Mr. Gomez lived in Building B, not Building A, across the street from where the victim's apartment was, and had moved out 7 months earlier.
Was that evidence introduced at trial?
Yes, it was. There's a question about the DNA results from Justice Graney. The results came back of a match of male DNA mixed with female DNA. The female DNA matched the victim. The male DNA matched Mr. Laguer, and the match would occur out of 1 out of 100 million people. And also, as to the question of what provoked the admission that Mr. Laguer made at his 2003 parole hearing in regard to the tampering, we, the Commonwealth, had submitted paperwork to the parole board beforehand, and had submitted the fact that Mr. Laguer had told a journalist in 1994, an Esquire magazine writer, that he had indeed tampered with his saliva sample by mixing his saliva with another inmate's. Mr. Laguer then filed that article with a motion for revision of sentence, or a petition for revision of sentence, as part of a filing with the court. So it's on record, which is how we came to know about it. The parole board member specifically asked Mr. Laguer, who was represented by Mr. Rehnquist at that hearing, whether or not he had tampered with the saliva sample. And after some finagling, he finally did admit, yes, I did tamper with it. So that is an admission made under oath before the parole board.
When we get down to the bottom line here, do you concede that the Commonwealth didn't provide the fingerprints, the information about the 4 fingerprints that were on this telephone?
What our position is, Your Honor, is that yes, we had a duty to provide scientific reports, and yes, there were specific requests for the fingerprint reports, which are memorialized in letters between counsel found in our appendix at pages 75 to 78. And what I would ask the court to do is to specifically look at those letters, because in the first letter, which is dated November 29th, Mr. Ettenberg, who is experienced defense counsel, says on page 75, he wants to know whether the Commonwealth will be using a fingerprint identification, and if so, where could he get a copy of the report. Subsequent to that, on December 5th, Mr. Lemire, the prosecutor, telephoned Mr. Ettenberg and left the message that you, Justice Cohen, said that there was a negative match with the fingerprint, which is what Mr. Ettenberg took to be the only partial print in the case. As it turns out later, just as an aside, there were not 4 complete prints found on the phone. There are 4 latent prints, which in Commonwealth versus Patterson, Justice Cordy very nicely put out. They're not complete prints. They're smudged, they're blurred, they're partial. So these were all partial prints that were found on the phone, and they probably did include the partial print.
How do we know that they're partial just because they're latent? Latent doesn't mean that they're...
As a definition, Justice Cowen, is not the full print that you would get by rolling someone's fingers on a fingerprint card.
You'll never... Couldn't we take judicial notice that it's extremely unusual that you'll get the full print that someone takes when they make a fingerprint identification, when they put their fingerprints down for the police at the police station? You probably will never get that at a scene.
Exactly. That's my
okay, so
point.
When you say partial, latent, it isn't really...
Latent
partial has a different meaning. It could be too small to identify.
Right. But in this case, it was identifiable. I agree with your definition or your interpretation of the negative match. A negative match needs negative. There was no match.
The fact of the matter is that at the time, did the prosecutor know at the time that there were 4 and maybe 5 prints?
The prosecutor never saw this report either, Justice Marshall.
But there's no question that this was an agent of the Commonwealth, so we're not getting into that issue. So
here appears to have been the problem with this, that this fingerprint was generated the day after the defendant was arrested on July 16th. Trooper Martin, who did the state police fingerprinting, wrote at the bottom of his report that he had telephoned Detective Kerrigan, the Leominster police detective, and informed him via telephone of a negative result. It appears that, from what I get from the prosecutor, is that the prosecutor received a phone call from Detective Kerrigan saying there was no match for the fingerprint, and that he then...
For that fingerprint.
Which is all we knew about, too. The one partial print that Detective Kerrigan had found on the phone, which was memorialized in a police report that Mr. Ettenberg knew about right at the very beginning of the case.
Right. I mean, the germ of this problem starts with the fact that Kerrigan himself had only found one.
Exactly.
And was always ignorant of whether there were 3 or 4 more.
We assume so,
So
Your Honor.
everybody was operating on a mistaken assumption, and for some reason, unbeknownst, and I must say somewhat unfathomable, a state trooper did not send his report.
We don't know what happened with it either. We have, during the course of the DNA proceedings is when this whole fingerprint report issue came up. Defense counsel, during the DNA proceedings, had asked us to go out and do another global search for any evidence that might be out there, which we agreed to do. We were surprised as anybody when this fingerprint report popped up, never having seen it before. And all we have is a one-page report with carbon copy typing on it. It doesn't seem to be there's anything on the back. The over for additional that is written at the bottom of the page, which you can see on page 96 in our appendix, is part of the printed form. It's not typed by Trooper Martin.
Can you answer, though, does seem to me some significance that, one print doesn't mean much if you're talking about somebody grasping a phone to pull a cord out. 4 or 5 mean a lot when you're talking about someone grasping a phone to pull a cord out. In that sense, doesn't this go beyond just cumulative?
I would say not, only because of what Mr. Ettenberg said in his own affidavit of what he would have done had he known of the 4 fingerprints, which probably most likely were the victims. The evidence shows that she very rarely, if it weren't someone from the police or the medics, she really rarely had anybody into her apartment. She didn't socialize. She was very quiet and kept to herself. No one ever tested this phone for the victims' prints, and my guess would be that's who they would belong to. But we have to look at...
But if I may
Yes.
interrupt you,
I'm sorry.
if that's the case, that's in addition to the fact that it may not be cumulative, if and there is the basis for an argument because of the means of binding her hands, that somebody must have grasped the phone.
The key question is every time you grasp anything, meaning that you were leaving a fingerprint? And
Of course
not.
No, what I'm saying is that the Commonwealth can make that argument. It seems to me that our role here is not to make the Commonwealth's argument, but to see whether or not there's a plausible argument that can be inferred from the evidence, and then the jury can decide. Was there any testimony from the victim, for example, that her assailant was wearing gloves?
Socks and jogging shorts, Your Honor.
No gloves.
No gloves.
So
no.
the jury could have been informed of that point, because we know that people who commit heinous crimes sometimes wear gloves. But the fact that she was quite specific in her identification of the clothing and didn't include gloves, if you think of socks and jogging shorts, I think gloves might have been observed.
Well, I think the question comes down to the prejudice as the bottom line. And we have to look at what Mr. Ettenberg would have done had he known about the 4 fingerprints.
It's very hard to do that in retrospect. It is genuinely difficult to do that in retrospect because counsel makes strategic decisions based on what they have, which is why we have the rules that say you turn over all of the evidence. And here, I, for one, can think of arguments that could have been made, positions that could have been taken. Maybe he might have wanted to have it tested against the other alleged suspect, maybe not. But that doesn't seem to me to answer every possible potential use of this evidence.
But in this case, we have the affidavit from Mr. Ettenberg that
Yes.
sets forth in paragraph 7 what he would have done. He said specifically, had I learned that 4 complete fingerprints had been found on the telephone rather than 1 partial print, and that these had not matched Laguer, I would have pursued additional questions of Detective Carrigan concerning his efforts or lack thereof to match these prints to anyone else and to exclude the victim. But of course, if Detective Carrigan had been aware that there were 4 additional prints, Detective Carrigan's testimony on direct would have been very different. So, and also, he says, additionally, I would have made the exculpatory nature of these prints and the lack of effort to identify them important parts of my closing argument. So nowhere does Mr. Ettenberg say that he would have tried to match them to Mr. Gomes or to anybody else. We know what he would have done. He sets it forth. And to that extent, the prints, he had the evidence, and he did make the argument that there was no physical evidence in the apartment linking the defendant to the scene, and he had it, and he made it, and he made it
But if
successful.
one of those fingerprints had matched some other person who had who could be arguably the third-party culprit, wouldn't that have changed this trial strategy and perhaps the outcome of the case?
What if they had, Your Honor? Well, the question is, would Mr. would the Commonwealth or Mr. Ettenberg have wanted to have those prints tested? That comes down to the question. And it appears from what he says in his affidavit. He was very happy with the tactical decision he had made, and as Justice Sussman and Justice Cowan pointed out, when you have a defendant who is a young 20-year-old black male who's raped a woman in a housing complex for the elderly, and you were trying to make arguments for defense as to alibi and misidentification, and he also made a third argument of sloppy police work. The sloppy police work argument was promoted by the fact that there was only one partial print. As Mr. Ettenberg said in a direct question to Detective Kerrigan, the defendant was there for 8 hours. The
But he
rapist,
wouldn't have made that argument.
oh,
I mean,
he
in other
tells
words-
us what he would have said, Justice Marshall, in his affidavit.
I mean, on the one hand, you're saying the fact that he wouldn't have tested for I can't, I mean, when somebody says use it in closing argument, I mean, maybe he would have cross-examined, the detective further, and the detective would have said, I knew nothing about this, I took one print,
And
correct?
he testified truthfully to that, yes, that he took one print.
Of course he testified
If it had all
truthfully.
been disclosed, Detective Kerrigan's direct testimony would have been completely different as well.
Absolutely.
Right, he would have testified as to
But
4 or
going
5.
back to the DNA evidence, that seems to me to have an awful lot of relevance here.
We agree with you,
I
Justice
mean, a
Gray.
motion for new trial is allowed when you've got some doubt that justice wasn't done. Here we've got DNA evidence, 100 million to 1, examined by the defense, requested by the defense, done by their expert. The only other theory they got is that it might be this Mr. Gomez, who had moved out of Building B 7 months before. So what is this all about? Some big hypothetical that these
That-
prints might
This is an
really
unusual...
belong to some party? The DNA now conclusively establishes they did not.
Well, it's an unusual procedure posture, because most people don't file a motion for new trial after DNA has implicated them to the extent of 1 out of 100 million.
But it's not also the DNA, it's also his admission that he
Yes.
mixed another inmate's saliva with his when he knew he was going to have to give his saliva for a test. And would an innocent person do that?
Well, it also...
But even guilty people are entitled to fair trials, aren't
Absolutely, absolutely, Justice Ireland. We're not saying anything different. I think as to the DNA in this case, looking at what Judge Hillman did when he considered the motion for new trial, he dropped a footnote in his opinion, because he didn't know quite what to do with it either, because of how you analyze this. He had been the judge who sat for 2 years on the DNA proceedings, hammering out how we were going to test this DNA. Was there enough to do replicate testing? Was there not? Authenticating the rape kit, because it had never been touched during trial, because we had no physical evidence, because we
I
didn't
assume
have a
the
blood
test
type.
was done by a reputable
Dr.
lab.
Blake of the Innocence Project, Your Honor. Yes.
Of the-
O.J. Simpson's DNA expert. While watched by a DNA expert from the State Police Crime Lab. They barely got 100 sperm out of the
The
rape kit.
defense hired this
Yes,
expert.
and paid for him, yes.
So what did, now returning to the point, Judge Hillman did what?
Because he was the judge during the 2 years of DNA proceedings, he had judicial notice of the results because he had the results sent to him as part of his orders. I think in this case it was proper for Judge Hillman to take into account, which is how he put it in his order, the DNA results. He doesn't specify how he did it, but I think in this particular procedural posture, him having been the judge who oversaw the DNA proceedings, that he was entitled to take that into account, perhaps, as you're saying, as to the significance of whether justice has been done in this case. I only wanted to add one point, and that would be possibly addressed to Justice Cowan. As to our argument about fraud on the court, this is not the first time this court has heard Benjamin Laguerre's appeals. In 1991, this court considered a number of issues on direct appellate review, one of which was whether or not Mr. Laguerre's lawyer had been ineffective for failing to get his blood type. His blood type was unavailable at the time of trial for us because he intentionally tampered with a saliva sample. His tampering and his direct violation of a court order to provide a saliva sample to give the Commonwealth a blood type constitutes fraud on the court. And I think for that reason alone, if for nothing else, this court should deny him relief in this case, consistent with the other cases on fraud on the court. He has made an admission that he committed fraud on the court in direct violation of a court order. This has been an ongoing pattern or scheme of his. This court has expended a number of hours and time on his first motion for a new trial that came before you, absolutely based on the issue of, I didn't have my blood type tested, that wasn't fair. He himself had caused his blood type not to be part of trial. If indeed he had been found not guilty, it may well have been because he tampered with his evidence. And we would like this court to make a loud and clear statement: the defendant should not be defiling the integrity of the system and getting away with defying court orders in order to predicate their motions for new trial on new claims. And that's exactly the underlying claim that is being brought here. Defendant is saying his fingerprint report was so important because there was no physical evidence, no blood type evidence linking him to the crime, whereas Mr. Laguerre's own doing that there is no physical evidence linking to the crime, he should not be able to benefit from his own wrong in accord with the theory set forth in Commonwealth v. Edwards by Justice Cowan. Thank you.
Thank you, Ms. Hoffman.